Gujarat, how many matters do we have?
My lords, I believe there are 3 matters. I am appearing in Kirti Agarwal and others versus High Court of Gujarat, which is writ petitions.
Just one second.
There are 2 other petitions from the Gujarat High Court.
You can mention yesterday's numbers because it'll be so much easier for us, because we have just.
501.15 months.
4 and 1. 14 and 15 are connected, right?
There are 3 petitions, I believe, my lords. Soumya and others, Kirti Agarwal, 14, 15, and 16.
The 1-4, you're appearing in 1-5.
Yes, my lords.
So it doesn't.
My lords, at the outset, I must say that there is a difference between the matters that were argued yesterday and my matter, in so much so that the question of the reference of Tej Prakash is not directly involved. The common link, of course, is that there is illegality involved that we are
But then
challenging.
why should we'll send this back to the 2-judge bench.
Your challenge here is basically on the ground that Shetty Commission as well as All India judges says the cutoff should not be imposed at all.
Yes, my lords.
That's the point.
Yes, ma'am. And my lord, what has happened?
That's not the experience for a difference.
That is why it is my role, my lords, as an officer of the court, to
Some
mention
of them are saying that.
that it,
Won't be covered by the Gujarat matters, you are saying the same thing, right?
that is right, my lords.
Then the point was whether the
There is a right
whether the
impose
right to
cutoff.
impose the cutoff at all in view of the judgment of in view of the Shetty Commission report and the judgment in All India Judges
Yes,
Association.
ma'am. The only difference, my lords, is that subsequent to the Shetty Commission, where a specific direction was given to all the states to implement, the Gujarat High Court in the year 2005 had in fact amended their rules in terms of the All India Judges
In
Association.
your case, the rule itself in 2011 provides for a Viva Voce test of 40% and a cutoff.
That is right.
Which will challenge the
That is
validity
right.
of that. Whatever.
So this does not arise before the Constitution bench.
I appreciate that, my lords. There is a difference in the question, but we are still challenging it on grounds of illegality and then the
That's
judgment.
Regular.
May I just have 1 second, Lord? I'm appearing for the High Court, my lords.
Yes.
Lord, these rules were challenged, carried it up before this honorable court, and SLP was dismissed. I must point that out.
That you will mention before.
That you can mention before the regular bench, actually.
Very well.
And will it then, you may kindly consider whether they should go with Salam Samarjit, which was referred by Lordship yesterday to the 3-judge bench, or these matters should go to 3
Because there is no difference of opinion here. Samarjit was because of the difference of
Miller, exactly the same issue again. Salam Samarjit was again on the same issue.
My lords, the
referring to a 3-judge bench. But the thing is, the moment I say 3-judge bench, it's something else. And what will happen is it will take a little more time. If you go before a 2-judge bench, you'll get a bench hearing immediately.
2022 appointment.
That is the reason many
would be-
in many cases facts would have led to the dispute being resolved. We don't really know. These are 2005 rules and 2019 is the advertisement. So therefore, let it go to the 2-judge regular bench.
That
And
bench
if they
can
want,
take
they
a
will
call.
refer to it. Or else-
As a lordship.
Because despite holding in favor of the petitioners in the other case, just because of passage of time you won't grant relief. So it's better that you should try and get a
That is what we're
opportunity.
trying to beseech, that even in these cases, there is
Therefore,
illegality.
strategically 2-judges bench should be the option for you.
I
You
appreciate
are appearing in which matter?
it.
This.
Whatever you
That bit can be.
argue.
The learned counsel appearing on behalf of the petitioners, Gujarat wale matters mein, the learned counsel appearing on behalf of the petitioners are agreed in stating before the court that the issue which has been raised in the reference to the Constitution bench in Tej Prakash Pathak Pura Naam Le Lo does not arise in this batch of cases. Let's stop.
Hence, it has been submitted that the matter may be placed before an appropriate bench for disposal. Full stop. Mr. Nikhil Goel, appearing on behalf of the Gujarat High Court, also has no objection to this course of action. Full stop. Hence, these three petitions shall be delinked from the batch of cases before the Constitution bench and shall be placed by the registry before an appropriate two-judge bench for taking a considered view of the matter.
My lord's only request is for it to be agreed listed matter.
The registry shall do so within a period of 2 weeks.
Regret the opportunity of appearing before your lordships.
Yeah, we were also thinking that you would appear and argue. This is a very interesting point to argue.
My lords, I can navigate. Oblige, my lords.
Now, which is the next lot?
Guwahati.
कल केरला हो गया था ना? गुवाहाटी हो गया, मणिपुर हो गया, केरला हो गया.
गुजरात का प्रॉब्लम
ना पर
Manoj, Guwahati.
you are appearing for Guwahati. There are three matters from Guwahati. Guwahati is 501.2, 501.3 and 501.11. Yes.
advertisement.
Manoj, in my case, like Mr. Mukherjee had pointed out yesterday, the rules which are there, the Assam rules were implemented in Manipur.
Yes.
So the same rules apply to my case. Now, allow me to.
So should this follow the same course as
No,
Manipur then?
No. I'll tell you why, Manoj. In Manipur's case, on the 12th of January 2015, the full court takes a resolution. Thereafter, that resolution is communicated to the petitioner therein, not the resolution, pardon me, the fact that he has been called for a viva voice. In my case, what happens? I'll start from after the viva voice, my lords. The notification for advertisement was issued on the 18th of January 2011, which is, my lords, it's annexed.
Take the dates from you in a minute, but
Yes.
just give us in
Yes.
1
nutshell,
minute
I'll
just
tell
the
you.
essence of the matter.
Just the 3 dates you just give
Yes.
us. Advertisement.
My lords, advertisement
and
is
amendment.
18th January 2011.
You are in 501.2, right?
501.2 Vishwajit Prasad versus Guwahati High Court. 2, 3 and 4, my lords. Connected, same matter.
Yes. You are appearing in all three.
Yes,
And 501.11 also.
yes, my lords.
That is Mufida Haq versus High Court.
Yes.
All right, tell us the dates. Give us the dates. So that
Like I said, 18th January 2011 is when the advertisement was published in terms of the rules then prevalent, which is the Assam Judicial Service Rules 2003.
Rules 2003.
Yes, my lord.
Yes.
My lords, thereafter the preliminary examination, I'll not give that, that's not really important, my lords. I'll come straight away to the viva voice. My lords, the viva voice was conducted
29th October.
on 29th of October 2011. My lords, now this is where the difference starts. Now, the rules say, which Mr. Mukherjee had shown to you yesterday,
Complete the dates so that.
my lords, 29/10/2011 is the viva voice, and the select list, which is the final list declaring the successful candidates, was published on the 1st of December 2011. This entire process took a period of 12 months, right from January until December.
Right. Right.
My lords, now the only difference in my case is that after the viva voice was concluded, by way of the rules, it was prescribed that they ought to have published the cumulative grade list, the merit list. Now, in my case, there was no merit list which was published at all. So when the results were declared on the 1st of December 2011, they only published the names of those 5 candidates out of the 19 candidates who were called for viva voice to be selected for the grade 1 services.
With 5 candidates notified.
Yes, Manoj. Now, thereafter, I approached this honorable court by way of a 32, which was withdrawn with liberty to go back to the High Court. I then go back to the High Court by way of a fresh writ petition, Manoj. Now, in that writ petition, prior to that writ petition, I also filed RTIs. Soon after the results were declared, which is 1/12/2011, I filed
RTIs on the 7th and 9th of December 2011, seeking the information of the marks obtained by each of the 19 candidates who appeared for the Viva Voice after having qualified the mains examination.
So Viva was conducted for 19 candidates.
19 candidates.
Yes.
My lords, now after I sent my RTI, after the declaration of the result, we were hopeful that the RTI would disclose the marks, but the RTI came to be rejected after a period of 1 month, which is a statutory time.
Right.
Thereafter, my lords, like I said, on the 13th of February 2012, I approached this Honorable Court under Article 32, but that petition was withdrawn with liberty to go back to the High Court. Thereafter, I go back to the High Court in July 2012 by way of a fresh writ petition. Now, my lords, this is where the interesting part comes in, that until now, I don't know what my marks are, what I have obtained either in the mains or in the Viva.
Yes.
Now, before the High Court directs on the 8th of November 2012 that you please disclose the marks to the unsuccessful candidates who are petitioners before the High Court. So then by way of a letter which was issued to me by the High Court on 9th of November 2012, the marks were disclosed to me. My marks, the unsuccessful candidates and the 5 petitioners who basically approached the High Court.
Yes.
My lords, now after the marks, my marks are disclosed to me on the 9th of November, the High Court files its counter affidavit before the High Court on the 26th of November. My lords, if I may be allowed to read 2-3 lines from that counter affidavit.
Just tell us orally.
Tell us orally.
Yes, my lords, in that affidavit, the High Court says, citing the rules, and I'll take you to that rules, which my lords had rightly pointed out yesterday that it's not for interview, it's only for cumulative marking on each questions of written examination. But the High Court says that they had the power under the rules and they have exercised their discretion rightly. While
What?
in the counter affidavit, they say that by prescribing a benchmark of 40%, there has been no error in jurisdiction committed by the High Court.
No, what they say is 25th of November, they have passed a proceeding.
Yes.
We didn't get that. 25th of November is the decision which was taken
Yes.
to prescribe a cutoff.
Yes.
That is what has happened.
Yes, ma'am.
25th November.
Was conducted on after the Viva was.
After the Viva.
That's the crucial.
25th of November.
25th
2011.
The proceedings. You can. So that you are saying post-interview.
Post-interview, my lords, they have introduced a benchmark and they have said they have exercised their discretionary power while exercising that benchmark. Now, my lords, without getting into the judgments and everything, we are not challenging the power of the appointing or selection authority to fix
The benchmark.
any minimum marks that they can fix. That's a matter of policy decision. What we are challenging, which is why I say that we fall under the reference, is because those rules were made applicable after I played the game, after I participated in the interview.
Yeah.
25th of November.
The reference clearly arises here.
Yes, my lord.
If I may clarify, there is a factual error. I'll point it out once.
Just tell us in a second. I mean, we can.
Cutoff mark was fixed for language paper, paper 4, not for Viva-Voce.
Correct.
So when was it fixed?
It was fixed later, but as far as the
Give us the date.
25th November.
25th November, right? When was the cutoff for the language
it is
paper fixed?
prior to the Viva-Voce, because only those who scored
Just give us that.
Crucial point.
No, that's the
What
most
you must
important.
specific date it is coming, because the rule
So
doesn't.
just give us the date. He will agree with that. Show us, because on the record there can't be two differences.
No, that's what I'm saying. The date specifically is not on record, but it is prior to Viva-Voce. Because
That's
unless
what you will have to demonstrate to us that it is.
That,
correct.
yeah.
it's there in the page one, this reply before the High Court, it says 40% cutoff mark was fixed for language paper.
Is it correct that the cutoff was
Well,
fixed for the language
allow me-
paper only?
No, allow me to clarify, my lord.
All right, we'll hear you later, yes.
Allow me to clarify. My learned friend has rightly pointed out this thing, but allow me to clarify. There were 4 papers for written examination. Paper 1, paper 2, paper 3 and paper 4. Paper 4 was the language paper. Language paper was only a qualifying paper, which is in the Assamese language for the state of Assam, because since grade 1 officers will be operating in the district judiciary for the local language. Now, my lords, para 10 of their counter affidavit before the High Court, that paragraph has to be read as a whole, and preceding that para, they deal with the language paper. Para 10, they say that with regard to the statement made in paragraph 9A of the writ petition, I say that by prescribing a benchmark of 40% in the paper 4, the High Court has committed the High Court had not committed any error in law or jurisdiction. Now, this is the interesting part. The selection authority has always discretion to fix its own standard of evaluation, and the High Court has exercised such discretion. No discrimination or arbitrariness has been directly or indirectly done therein. A written examination is not sufficient to assess overall intellect and personal quality of the candidates, which can be done at an interview only. So, my lords, this benchmark of 40% could not have been fixed for the language paper, because if you read that counter affidavit before the Supreme Court,
So they seem to have done it for both.
they seem to have done it for both. And in any case, my lords, the language paper is a qualifying paper. That doesn't add to my marks while calculating the cumulative grade list.
So you have no problem that they fixed a benchmark of 40% for the language paper.
My lords, this statement is actually,
You have cleared the language paper?
yes, which is why I was,
Then that's irrelevant for you.
that's irrelevant.
But then, therefore, you are claiming that, well, apart from the 40% benchmark for the language paper, they also fixed a qualifying cutoff for the viva voce.
For the viva voce, which is evident at para 10 of the counter affidavit filed before the High Court, which I just read out to you, my lord.
But it can't really be a matter of averments in the pleading, in the affidavit. I'm sure there will be a proper decision taken as to whether it is intended for a benchmark for the written exam or viva or what.
Finally, we need to see.
No, you must check up and tell us. It can't be, don't say that I have the file with you. Tell us what the file says.
For paper 4 is language.
So there was no benchmark, there was no cutoff for the viva?
No, the cumulative mark was taken. They scored much less. That was their grievance. All of them scored less than 10 marks out of 50
In the interview.
in the interview. Total of both 3 papers plus the interview, viva was, together they were all below the selected 5 candidates.
Then they're out then, if that is so.
Show us that.
Show us that, show us the relevant file then. We'll just look at it, we'll look at the record, then the reference.
A matter of controversy, actually.
Because he says that as a High Court, that we never fixed a benchmark for the interview. Now, maybe they said that in the para, but it's a matter of record. It can't be a matter of the counter. Let's just see it. Because have you flagged it? Have you flagged the relevant part? Don't make us go through the whole file now. एक मिनट उन्हीं को दे दीजिए वो फ्लैग करने दो
नवंबर का एक लिखना था
ये क्या है
This is a judgment. No, this is a full court. This is exactly 25th November. This is what we were to see.
all right let's just see quickly
Correct.
this.
This was not there on record. I was looking for this. Correct. This is exactly relevant portion.
The 4th page, 3rd page, at the back side.
Yes.
The marks are there, as on the district. This is the committee report. This was approved by the full court.
Have they imposed cutoff? It doesn't say that they have imposed cutoff anywhere. But they are saying that they have the power to do it and all that.
in the first page, they say as well as 17.5% mark out of 15 paper 4 at the last line. Called for interview and my vows.
So Jose, the 5 persons named at page 7,
Yes, ma'am.
they are all in seriatim with the highest aggregate
Yes,
score.
they are all 5 in Syria.
That's what I noticed.
I have calculated it here, my lord. It's all of them are above the petition.
Yeah, ones were selected and they. Jose, it appears
Yeah.
that you have also added the marks of paper 4.
No, that's here it is added, but I have separately calculated, my lord, for the purpose of selecting 5 of them.
He says, for you, minimum prescription on the basis of which he was excluded. That doesn't seem to be there.
There is no decision. There is the rule provides for suitability. So those who have not,
But contrary to what you are saying that, we never took the marks of paper 4 into account.
right?
You have to only qualify. You have added the marks of paper 4 also.
No, that is for the here, but the total calculation it has not taken into.
No, but if you can go to page 4, for instance.
Yes.
Right,
Abhijit Bhattacharya is the first candidate.
right.
Just a test case. Now, if you see,
First 3 papers total 188, my lord.
now just see, Pranjal Das is the first one who gets 284.25, right?
About 11th or 12th item there, Pranjal Das.
Kanchal Das, right.
He is the first one in merit aggregate. Let's just calculate his marks.
Sorry, my lord, that one. On page 4 only. your-
Page 4, the chart.
Pranjal Das is the highest candidate,
Yes.
284.25. All right, take the first candidate, Abhijit
That's right,
Bhattacharya.
my lord. That's
Take the first candidate, Abhijit Bhattacharya,
right.
who gets 257. 257 is the total of 74 plus 67 plus 47 plus 29 plus 40.
That's right.
So you added the marks on paper 4 also.
No, that is for, that's for just making a statement, my lord. But
All right, then
total of first 3 papers and the interview comes to 228.
228.
228.
Okay. So,
If I can just say who are all the selected candidate, the marks, my lord.
the first selected candidate was Pranjal Das, right?
That's right. That's right, my lord.
So who gets 81 plus 74 plus 56 plus 42 points?
That's 253.25, my lord.
Okay,
Total of 3 plus 1.
okay. Likewise, for all the other candidates, selected candidates, you only took the 3 papers
That-
plus the interview.
That's
So you didn't apply a cutoff in the interview at all.
the interview, there is a suitability clause.
But did you say that you must get a minimum mark
No,
in the interview?
No, it was not stated anywhere. At least on the record, it is not there. Because all the 5 persons who are selected are above those who are petitioners here.
Oh, I see.
On total of 3 plus
And
1.
none of them were rejected on the ground that they didn't get 40% in the interview.
No, that's not at all.
It is not borne out of the record.
In fact, the
Yeah.
page
Just see
6,
page 6.
page 6, the
Let's
top
read that.
paragraph.
Yeah.
They went by Schedule B instructions.
That's right, Schedule B.
Schedule B instruction, that paragraph we read, the top paragraph.
Yeah, it says, in other words, the
Hmm.
selection has to be made on the basis of the aggregate marks secured by the candidates in the written examination and viva voce.
No exclusion.
There's no exclusion here.
So if there is no exclusion, what's?
Then the
point?
reference doesn't arise here.
Kindly have para 20 of the judgment passed by the High Court. What they
But
say
you
there.
make your submission, no?
Now you show us, we've got the record now.
My lords, para 20 of the judgments clearly says that because the petitioners herein did not obtain 20% marks in the Viva voice, therefore they were found suitable for appointment.
Unsuitable. you mean.
Unsuitable, sorry, my lord.
Right.
Stand corrected.
No, but that's not so. We've got the record now.
My lord, the point is that this,
Whatever
this
the High Court said in the judgment.
my lord, this record which my lord has produced, this record was never made available to me, number one.
Have a look at it for 2
No, no,
minutes.
no, these are proceedings. Actually, the whole
These
thing,
are official records.
the whole thing turned on your argument that the proceedings that took place on 25th of November 2011
Yes.
were post-interview, and during that, by virtue of these proceedings, an imposition of cutoff was imposed. That's the only point to bring you within the ambit of the reference.
This petition.
My lord, but then this, but
So
then
we have seen this.
Dismiss the petition, no point in sending these back also,
Yes,
because
but
there's nothing in this.
my lord, may kindly appreciate
And
one thing.
2011 advertisement, you have to make out a case, 2011 advertisement, and matter has been pending under the assumption that they have imposed this. We have seen this, there's nothing in this.
My lord, the High Court,
Further selections afterwards.
We'll close this, I think, now.
We will- yes.
All right, chalo. This is a selection to, again, the district judicial. Grade one service. You call it grade one in Assam, right?
my lord, may
And
kindly.
the rules are the Assam Higher Judicial Service rules
2003.
of
2003.
2003.
All right. The selection in this batch of cases, the selection which is in question, the present batch of cases, is to the grade one service of the Assam Judicial Service, which is governed by the Assam Judicial
Judicial
Service
Rules
2003. Full stop. Next. The relevant dates for the purpose of evaluating the merits of the petitions are as follows. Colon. 1. The advertisement on 18th January 2011, the advertisement was issued under the Assam Judicial under the rules of 2003. Full stop. This was followed by the written examination, which consisted of
Three
three papers, and for three
Language proficiency.
which consisted of four papers. Full stop. Of these, the fourth paper, into brackets, paper 4, was for language proficiency. For the region. For the region. Full stop. On 29 October 2011, on 29 October 2011, the Viva Voce was conducted for 19 candidates. Semicolon. 3. On 25 November 2011, the Committee for Recruitment of Judicial Officers conducted its meeting for selection of candidates for direct recruitment to grade 1 of the Assam Judicial Service, Tripura Judicial Service, and Mizoram Judicial Service for 2011. ये तीनों का था. 4. On 1 December 2011, a select list of successful candidates was published, in which 5 candidates were notified to have been selected. After withdrawing a petition which was filed before this court under Article 32 of the Constitution, the petitioners moved the High Court in a petition under Article 226 of the Constitution. Full stop. During the course of the hearing of the petitions, the High Court directed the disclosure of marks, following which marks were disclosed
Only of the unsuccessful candidates.
To the unsuccessful candidates who are before the High Court. Full stop. Next. The submission which has been sought to be urged before this court is that you lost before the High Court, right?
I lost.
The petitions failed before the High Court. Full stop. The submission which has been urged in the proceedings before this court is that after the interview was conducted on 29 October 2011, a cutoff of 40% marks was prescribed by the Committee on Recruitment on 25 November 2011. Full stop. In order to support the submission, Learned Counsel relied upon the counter affidavit which was filed before the High Court. Full stop. In order to obviate any controversy on the factual aspect, the learned counsel appeared, Mr. Jose, appearing on behalf of the High Court, has placed on the record copies of the minutes of the proceedings of the Committee for Recruitment of Judicial Officers held on 25 November 2011. Full stop. The submission which has been urged on behalf of the High Court is that that it was only that paper 4, which was a qualifying examination for language proficiency, in which a cutoff of
17.5 mark, that is 35%.
Of 35% was adopted. Full stop. The minutes which have been placed on the record make it abundantly clear that no cutoff was prescribed for the interview, and the merit list was drawn up on the basis of a cumulative aggregation of the marks which were obtained in the 3 papers of the written test and the interview marks.
My lords, if I may, I really apologize, my lords. If I may just say this, my lords, merit list was never published.
No, we are saying merit list was drawn up, we are saying. In view of the above factual background, the issue which was sought to be raised in the reference to the Constitution bench in Tej Prakash Pathak, so and so, would not arise in the facts of the present batch of cases. Full stop. The petitions are present.
Well, if I may kindly say, just say one thing, not on the
The selection in the present case pertains to the year 2011. Full stop. The officers who were selected in pursuance of the selection process have already taken charge. The High Court has also has also apprised this court that subsequently 2 further selections have taken place in the state for the state judicial services. That's all. So now we are done. So now we are done with
My lords, if I may just say something.
Yes.
My lords, I agree that I am out of the reference, so I really don't have much to say. But my lords, the only thing which I can say before my lords is that my lords have themselves held a number of judgments, like in state of Jammu and Kashmir was a district bar association, which is judgment written by my lords. My lords have clearly written that an important requirement of public appointment is that of transparency, my lords. My lords, in my case,
you're undoubtedly right that they should have told candidates.
I bow down to what my lords are saying.
No
I only say this.
The question is that you will not get any relief at this stage because the whole basis of the petition is now that we have verified it.
Lord, I only say that when this rule of law is when my lords are adjudicating upon this, my lord,
now look, we can't in a 2011 selection we can't set aside a selection on the ground of a lack of transparency, provided we are satisfied that the merit list was drawn up properly, which is what is found from the records.
Let's go to the next.
We'll go to the now. We'll go to Patna now.
Patna. Even worse. Different.
Yeah, so what your lordships indicated that your lordships thought, what I thought is I put my submissions in 5 pages, though these issues don't arise, but since your lordships thought if I could assist your lordships on these 2 issues, I thought I'd just put it down, and I'm sorry, it's just hard copy because I just, lordships have it.
But we will now first see the facts.
Whether it will arise or
Wait, does it arise?
It doesn't arise at all. I said yesterday.
It doesn't arise.
The evaluation process.
It doesn't arise at all. I said yesterday.
That has been the challenge in the petition.
you have not.
But the issue is not arising in the present matter.
In my respectful, but the Tej Prakash reference also doesn't arise. That's what I thought.
Yes.
I've tried to figure out if a lordships is.
Now just tell us in like 2 minutes.
Yes.
What are the facts here? So we'll see if there's any substance. If there's some prima facie point to be argued, we'll send the petitions back to the 2 judge bench. Otherwise, there's no point in just prolonging the agony of these candidates further.
Yes, Avinash Kumar.
Avinash is 501.1.
Yesterday.
The advertisement in this case was published in 2015, in January 2015. The advertisement was published in January 2015. no? This was a district judge entry level, direct from bar examination 2015. On 22nd March 2015, a screening. Today it is 501.7. Yesterday it was 501.1.
Yes.
This is writ petition 165 of 2017. Madam. Yes. Please.
Only those facts, Mr. Sharma, which will
Just give us,
first of all make us decide whether it falls within the reference or not. If it doesn't fall, we will protect you. We will not state
Yes.
unless it's so.
Unless it's so obviously
Obvious
that
that
we don't have to send it back before.
Tell us those.
Just give us a few 3-4 dates. That's
Yes,
all.
this advertisement was published in Jan and then
Jan of
March
2015, right?
Screening tests were taken. So where I qualified in the screening test.
When was
Then
the screening test, Mr. Sharma?
22nd March.
22nd March 2015. Written examination was conducted on 12th July 2015. But I obtained 127 in the written examination. However, the qualifying marks were 125.
You got how many marks?
127.
Qualifying were 125.
Yes, minutes. So
you qualified.
But I was not called for interview.
Yes.
The total 81 candidates were called for interview. Later on, that list was also shuffled and 5 candidates were dropped from there, 2 added later on. So this was some juggling up. So ultimately, I filed a RTI application on 18/4/2016, Patna High Court, seeking a copy of my answer sheet for paper 2. Paper 2 I had obtained 53 marks. So in paper 2, Milord, when I was given the answer sheet in the first week of July 2016, so I had received 0 marks in answer to question number 8, 10 and 23. So there were several limbs of the question which were answered by me. So all the limbs of the answer were given 0 marks. In a corresponding to this, question number 3, another candidate was given on the same answer 5 marks. So I was
given 0 for questions 8, 10 and 23.
8, 10 and 23.
Right.
So there were several limbs, 3, 4 limbs in the question.
What's the grievance now?
But I sought re-evaluation. The High Court said there is no rule to provide you re-evaluation.
So that's the issue.
That's the issue.
That's the issue. Re-evaluation is the question.
Yes, ma'am.
Why this is struck? So it's not a case of cut-off.
Where's the right to re-evaluation?
Yes.
And moreover,
Sanjay
moreover,
Singh
your
judgment
rules
will apply in my
provided a
case.
cut-off. Rules provided a cut.
What was the tag? Why was it tagged here? This Tej Prakash doesn't arrive here.
I was not very
also
fortnight
to
at that
detag.
point of
But now
I
tell us
made a couple of
something,
applications also to detag, but somehow it did not.
Well, there's an application to detag also.
So it was unfortunate on my part.
Why should we do this? Let's get a statement of facts from the High Court what actually happened.
No, please, I'll do
He's really concerned with questions 8, 10 and 23 of paper 2.
Correct.
You know, the easiest thing for us as a constitutional bench is that, look, we'll send it to 2 judges, but let's find out whether there's something worth arguing, then we'll do that, then. Now tell us tell us in 2 minutes what the facts are.
So the counter affidavit, which is I have inherited the brief, actually does not address, apart from saying there's no procedure for re-evaluation. So therefore, we can't entertain a request for re-evaluation because as per law laid down by your lordships in Maharashtra State Board, there is no provision for re-evaluation.
So now he has filed a writ petition where your lordships will then have to see whether what his allegations are that his question paper 8, 10 and 23 are marked 0, despite the fact that his answers were correct or even have some substance. So, I mean, he can show me the question paper. If I find that, yes, there is substance, then of course, I'll inform your lordships, yes, there is a primary 16, 15, 16.
I am already an official officer. I was selected in the subsequent examination. I am working as an official officer now.
He's already working
on that. On aggregate score, you come below.
Only 2 marks, by 3 marks only.
On aggregate score, you come below, meaning thereby your merit would not sort of connect.
Only by 3.25 marks, my lords.
Subsequently, I think
only by 3.25 marks.
You're already in service.
Yes. I'm so sorry. 2.25 marks. If I get one mark each in all these questions.
This 1 mark in a given situation could be a very big difference. Not just, you can't just sort of
see what are my answers.
Which year did you pass after the next year?
2017.
You made it now.
17 now.
Seniority would be affected. I would get the advantage of the seniority.
Even if we allow
Seniority, now we are not
have been working.
So we'll say that though the petitioners, both matters, right?
One. Second one is different.
All right.
Second
Though 501.1 mein kar lo,
Yesterday's
though the petitioner did not qualify for the in the selection process for district judges through direct recruitment in 2015-16, it is common ground that he has since qualified in joint service in the subsequent batch of 2017.
Recruitment of 17. We have got appointed in 18, if I'm not mistaken.
In view of the fact that the petitioner has joined service after being recruited in a subsequent batch, no case for the exercise of the
these questions are required to be considered. It would be most appropriate. Because the High Court cannot brush aside my answers just like that. These answers are reasonable. One has to see.
But
somebody
assuming you're right, we can't, assuming you're right, we can't give you seniority of 2000 of the earlier batch then.
No, it can be granted. If I am eligible, it can very well be because there were deficiency of seats also. All seats were not fulfilled. The advertisement was for 99 seats.
But
there were only, I think, 6 seats were filled.
Demonstrated that look, your answers are absolutely correct. You don't go to the High Court. You come in that 32 petition. You have to demonstrate ex facie that look, my answers are correct and I'm right.
I will demonstrate, my lord. If my lord permit, I will demonstrate before my lord or before that.
At the end of it, look, will we now say then 2023 that you should be given seniority of 2016 when you have already joined service?
Not if I am eligible, then it can be said.
And there is no provision for evaluation.
Even in Kerala, where we have held that the High Court decision is wrong, we have not given relief.
I understand. I'm live in that situation.
Can't unsettle, now the seniority of people who have joined 6 years ago. Other people have joined service 6 years ago. We can't now suddenly unsettle seniority in service.
The answer to this would lie in the very fact whether there were leftover vacancies of that year or not, and whether they were filled subsequently or not. So if there were leftover vacancies and they were not filled in subsequently, then my lien can come into play. If I prove my case, then in that case I can be.
No, Mr. Sharma, we'll consider
the principles of justice, my lord. This is again totally entirely.
We must also look at the concerns
and that's also by a High Court, my lord.
Section 501
calls for interference, my lord, with deep.
501.1, the High Court had amended the rules and provided minimum marks in the interview. So, and that rules are in substantive challenge as being contrary to SETI Commission. There is no rules. Rules of the game have not changed during the selection process. So, advertisement and the rules provided for minimum marks, and they have challenged the validity of the rules being contrary to SETI Commission. So, I'm not sure why it is here, but this is the substance.
Let me kindly post it before a 2-judge bench. It would be most appropriate. I will plead my argument before it.
The issue which has been raised in the reference to the Constitution bench in Tej Prakash Pathak, Pura Naam Likho, does not arise in the present case. Full stop. The petition is detached from the batch of matters and shall be placed before an appropriate 2-judge bench by the registry at an early date.
Let me pick some time, 2 weeks as early.
Within 2 weeks.
Deeply grateful.
No, this is 501.12.
12.
Not in my case.
No, you have my matters also. 501.12.
Not respectfully submit only one.
Dictated the order very softly. Dismissed.
No, Milord, I am so sorry that I missed to hear it. Milord.
No.
Milord,
Anyway, now
the
we'll take
only
up
position that
Rajasthan.
has to be-
Now we'll take up
Milord, just
Rajasthan.
one last suggestion. Milord. The only situation that has to be seen by this honorable court at this stage, Milord. What were the leftover seats at that time which were not, completed, and then whether they were fulfilled in the subsequent years or not. There are vacant seats for that year. So it is not as if that I will overrun someone
We'll not give you
in my
notional
selection of that year today.
No, Mr. Sharma, we can't give notional seniority like this. Yes. Rajasthan now. Rajasthan, who is appearing in Tej Prakash Pathak? Tej Prakash Pathak.
Just one thing can be added, may not replicate the very stance taken by the High Court in this matter.
All right.
This requires consideration.
All right. Tej Prakash Pathak now. Miss Dr. Bhardwaj, what are the facts here?
Lordship.
This is
What is the item number?
The reference order that clearly captures the facts also. So if
Reference
it
order.
This is 2009-10.
9, 10. 9 selection is of 9.
Lord.
And for translators, 4.
Lordship, I will just explain if my pen allows.
501.501.
501.
501 and 501.2, Lordship, I am hearing for.
501. 1 point?
Tarun Kumar and Tej Prakash.
All three, the first 3.
501.9, yes.
Lordship, I have no idea about the third one, but yes, I am appearing in two matters, Lordship.
501 and 501.9.
9 and 10.
She is appearing in 501.9.
1 and 9 I am appearing, Lordship.
Mukesh and Jain is the same.
Same
Same is
selection.
there, Lordship.
All same.
And what about, all right.
Only 3 matters are there, Lordship.
Right. Now tell us what the facts are.
Lordship, the notification, it had come in 17/9/2009.
17?
9/2009. An exam date was 19/12/2009.
What was the notification for? For holding the exam for?
Lordship.
For translators.
It was for employees who were actually working as a judicial clerks, UDC, in Rajasthan High Court. They were already in services, Lordship. And this notification for those employees who were already in the job and just to shift, promoting to the
This
translator.
was for in-service employees.
Service employees. Lordship, 21 eligible employees were appeared in the test held on 19/12/2009. There were 13 vacant posts of translators which was issued on 17/9/2009. Applicants applied as per eligible qualification which was possessed by them, which was only MA in English, Lordship.
There was no bar.
24/7/2.
I read notification
Go ahead,
of
just tell us,
2009.
Give us the date, give us the dates.
Lordship,
After the
dates is
advertisement, what
fine,
happened?
still I want to go.
That's the most important thing. Just tell us the dates and we'll go to the law.
2009, that I've already.
24.
17/9/2009, which was a notification, which was actually the Rajasthan High Court Staff Service. Applicants were invited for giving performer for the recruitment of 13 vacant.
Right, you told us. And 21 appeared on 19/12/2009.
Lordship.
Then
And Lordship, then the result was declared
on
on 22/2010.
22/2010.
Lordship. Lordship, till now, we were not aware that the rules were changed one day before 19/2/2010, which we came to know actually when once we filed writ petition before the High Court, and there when the counter affidavit was filed by the respondent,
19th
it was
February. 19th, your results were declared on 20th.
February 2010, the
19th,
notification.
they have enforced the 75%.
75%, Lordship, which was not even there, the
Right.
minimum and maximum, nothing was explained. It was for translators, which was actually to Hindi to English and English to Hindi. That was the only test prescribed in the 2009 notification. Kept vacant, only 3 were taken. Lordship, the employees who were, actually they had appeared in these examinations, which were my petitioner, we all are petitioners. They had scored 71%, 69%, 68%, 68%, 66%, Lordship.
How much? 71%?
71%, 69%, 68%, 68%, 66%, 57%.
Below 75.
Lordship. And Lordship, these were the marks which were actually they got, which they were not even informed, even till when I filed my writ petition, I was not aware. When I
So
filed
your
my
contention is
RTI,
now those who have been selected,
Lordship,
those who, and was there a Viva here?
Lordship.
There was a Viva here or no?
No, Lordship, it was only written examination.
Only written exam.
Because it was for
But
the
you were
translators.
75% minimum.
Lordship,
But
that
those who were
was
selected, those who were selected all got, 3 people who were selected got more than 75%.
They got Lordship.
And 10 persons
Lordship.
who were not selected at all
Lordship.
were all below 75%.
75%.
Were they
got
bound to fill up all the posts? Were they bound to fill up all the posts?
Lordship, what I am saying, had I been knowing that I have to prepare in such a manner that it is a competitive examination, I would have
You are
prepared.
starting from the stage of preparation.
Lordship, this is against the Article 14, Lordship. I am not given a chance.
Does that apply?
Don't even
They were
know.
not bound to fill up all the posts.
No,
So forget the fact that they laid down the 75% criteria later. They were not bound to fill up all the posts. They said, we'll take the first 3.
Lordship, may I read the reference
Not a case of
order?
a change of the rules of the game in that sense. You see.
Lordship. And Lordship, I want to read.
See, in the earlier case, for instance, the Kerala case, what happened was,
Lordship.
yesterday, which we heard, because of the fact that there was a change in the rules of the game, then though these people who were excluded, they had higher marks in the aggregate, they were still not selected because they didn't get the minimum marks in the interview.
Lordship, in
That is the problem.
Lordship.
Here, all of you are anyway below 75%.
Merit list, they just stopped
Yes.
at one particular
Only
post.
one line. There's, in the other cases, there was a revision in the merit list because of the change. There's no revision of merit list. It is still the same. Top 3, top 5, 75%, above 5. That is how it has been done in this case. So there's no change in the merit list in terms of preparation. So that is what.
No.
In all other cases, there would be a change in the merit list because of that introduction of qualifying marks. That is the
Lordship,
distinction.
I want to submit, Lordship.
It was very straightforward.
Lordship, 2002 rules I have filed, Lordship, and I have given the copy also. Lordship, earlier it was 75% only, and why? Lordship, it is,
Pertains to
Lordship,
selection
Lordship, it is very important. I have
conducted
waited
by
so long.
the
Just one
Rajasthan High Court
heard.
in 2009,
We have seen that.
2009-10 for appointment of translators.
Lordship, may I read one reference order? Lordship, this much chance I should get, Lordship.
Dr. Bhardwaj, you've read the reference order, but the point of the matter is this.
Lordship.
Your case is that after the examination was held,
Lordship.
they decided to have a cutoff of 75%,
Lordship.
and therefore there's a change in the rules
Lordship.
of the game. And
Which was
therefore,
earlier again 75% in 2002, and again they had come and changed in
Right.
2009.
There was no cutoff.
No cutoff.
There was no cutoff
Lordship.
when the advertisement was issued. Now, what they did was they applied a cutoff of 75.
Lordship.
All right, they took the first 3 candidates and then didn't fill up all the 13 posts. They just filled up 3 posts and didn't fill up the remaining 10 posts. There are 2. There's a basic answer to that. That they're not bound to appoint everybody at all.
Yes.
Second, you see, what we try to should tell you as a difference, or possibly you didn't realize that because you were not here in that matter yesterday. In the Kerala matter which we dealt with yesterday, they decided, the rules provided that the selection will be made on the aggregate marks in the written examination and the interview. These petitioners who are before us yesterday said that you applied a cutoff for the interview.
Yes.
So though we had higher marks than the selected candidates in the aggregate of the written plus the interview, we have been excluded only on the basis of the fact that we did not score the minimum marks in the interview, which requirement came in later. So there was a revision of the merit list. Here, all that has happened is that they said, look, we will not take anybody who has less than 75% marks.
Now, Lordship, what
I could have
happened?
said
In
top
next
3
year,
also. I could have said top 3
next-
also. Instead
No.
of saying 75, I could have said
Then
top.
what happened? Next year again they took the exam. They kept 75%. Nobody cleared the exam. 0. Nobody was taken.
That is what the
Then
translator is an important post for us.
to
We have the right judgment where to be
that
translated. There are so
nobody
many things to be
facts-
translated.
will take
Dr. Bhardwaj, this touches the first point that you made,
Lordship.
that you will have to prepare harder.
Lordship.
This is the first point that you made.
Lordship.
That's why.
Lordship, it is just a thing that now why did they come now? Again, the minimum maximum, there is nothing. You can come again because they did not get on 75%. That was the only year.
Lordship,
That was the only year when, that means only my batch, I am suffering, nobody else. My next batch is lesser than me and still they are on the post, Lordship. Test of arbitrariness, Lordship.
Full stop. The selection was for in-service candidates. Full stop. The notification for the examination
Lordship,
was
I
issued on
apologize.
17 September 2009 for a total of 13 posts. Full stop. 21 candidates appeared at the examination on 19 December 2009. Full stop. The result was declared on 20 December 2010. Full stop. The grievance of Dr. Ritu Bhardwaj, learned counsel appearing on behalf of the petitioners, is that initially on 24 July 2004, the cutoff, which had earlier been prescribed in the written examination, had been removed. As a consequence of which, on the date of the advertisement, there was no prevailing cutoff for the written test. Full stop. Learned counsel submitted that on 19 February 2010, 1 day prior to the declaration of the result, the High Court decided to impose a cutoff of 75% marks in the written test. Full stop. This, it has been submitted, is arbitrary since it would amount to a change in the rules of the game midstream. Full stop. On the other hand, the submission of the High Court is that, as a matter of fact, is that the High Court decided to take only 3 candidates who had more than 75% marks, having regard to the fact that translators were being appointed into translators were being appointed. Full stop. Next. It is a settled principle of law that it is that the authority which notifies a selection process is not liable, is not bound to fill up all posts. Full stop. However, it is equally well settled that such a decision must stand the test of fair procedure, of fairness. Not a case where candidates who were otherwise eligible for being considered were excluded as a result of the application of a new rule midstream during the course of the selection process. Full stop. The High Court was not bound to fill up all the posts which were notified for selection and decided to fill up only 3 posts, having regard to the necessity of appointing persons of the requisite merit as translators. Full stop. In the circumstances, the High Court eventually decided to fill up only 3 posts, leaving 10 unfilled in the selection of 2009-10. Full stop. The were again appointed only on the basis of merit. And the petitioners ranked below them in the order of merit. Full stop. Vote rejected. Yeah. Rejection of the petitions under Article 226 of the Constitution by the High Court has led to the institution, has led to the invocation of the jurisdiction under Article 136 of the Constitution. Full stop. For the reasons which have been indicated above, we find no merit in the petitions. The petitions shall accordingly stand dismissed. The reference to the Constitution bench shall accordingly stand
Lordship,
answered.
may I submit now, Lordship, one more thing, Lordship. We were not at all here for the merit of the candidates, Lordship. We had to decide one main important question.
As a follow, the reference to the Constitution bench does not arise in the facts and circumstances noted above.
Lordship, may I submit now, Lordship? I maybe heard only one point, Lordship.
Yes.
Here we were discussing about the whatever rules are made at the last time when the selection process has already started. This point had to be decided by the Constitution bench, Lordship.
All right, ma'am, I'll tell you one more reason.
Lordship.
Suppose they had not altered
Lordship.
that, suppose on the 19th of February, they imposed the bar of 75%.
Lordship.
Suppose they had not done that.
Lordship.
Were they still bound to appoint you? No.
Lordship, I am not at all talking about my appointment. I am talking is, Lordship, what now Lordship says today. It will be followed in all
Suppose-
the exams.
no.
We will not be told any syllabus and suddenly there will be any change at any.
Suppose, ma'am, suppose we ignore the decision which the High Court took on the 19th of February to have a minimum requirement of 75% in the written exam.
Lordship.
And suppose there was no minimum requirement of 75%.
Lordship.
All of you had therefore qualified. Even so, the High Court could have said, we are taking just the first 3 candidates who have above 75%. That's the difficulty in your case.
Lordship.
They can always say that we don't want people who have, say, got 57 marks out of 100 in the exam.
Go to 47 if 13 were
End of the
selected.
rule can be set up by the Honorable High Court or Supreme Court, Lordship, but we should be informed in time. I am just asking about that point, Lordship, what we had to discuss today in this Constitution bench, not the merits, Lordship. We are not talking about whether I should be taken on this post or not. I am talking whether such rules
We should be very careful about answering questions in the abstract.
Yes.
We should be very careful about answering
Lordship,
questions in the
may I,
abstract.
that's why, Lordship, I requested to read referral judgment, Lordship.
Read
The
that.
9, 10th, 11th, 12th, Lordship, if you will see, there he himself, Lordship, he clarifies that this is wrong when arbitrarily.
That will arise in a case where there is a right of appointment, but there is a violation of that right arbitrarily. In your case, the right of appointment doesn't arise
Right
because
of appointment to Lordship. Making of the rules when the selection of process is started, Lordship, it is the point, not
Now
the.
we are left with 501.8, which is National Council
Lordship,
for
that
Education
12 of
Research and
Manjushri
Training.
is very clear about it, Lordship.
All right. Ma'am, sometimes you have a law of this court which is holding the field from 74. Then you have a judgment of 2008. Let benches consider those cases and the facts of each case. Sometimes it's better not to, lay down these very rigid rules in a constitution bench.
In fact,
both
both
are
are different
But
aspects. of
bigger
fact.
issue
particularly
was-
in service
it
matters,
was-
always wise to look at the facts of a case and then take a decision, because you can adjust the equities.
so upon 501.9 and 10, are they different?
No,
No,
same
Lordship,
selection, same
They
selection.
are the same.
501,
Without-
501.9 and 10 में ये order आ जाएगा.
Yeah.
अच्छा, now 501.8.
Lordship, this is regarding conducting of examination, that is National Talent Search Examination conducted by the NCRT, Lordship. All India examination, selecting candidates on the basis of their merit to grant scholarship.
Can I have your name, please, counsel?
Lordship.
Your name?
Ashok Kumar Panigrahi, Lordship.
Yes.
The matter होने के बाद and before we take up the
Yes.
Yes.
Lots, initially, when the examination was, for the examination, the advertisement and the further process was on.
This is for a scholarship, is it?
For scholarship. It was initially that there are two parts of the test, that is mental ability test, then there is a scholastic aptitude test. In the scholarship aptitude set, there are two categories. One is language test, the other one is subjective test, that is science, mathematics, and social sciences, irrespective of the, as per the choice of the candidate, whether they are choosing science or social science or mathematics. Lordship, initially it was the issue that the language score will also be considered for the purpose of calculating the total merit of the candidates to judge their performance in the examination.
Language score also.
Language score, that is English. During the process, when the examination is on, there are several complaints received from various corners of the country that the English language, because most of the candidates are from rural background, they are not much conversant with the English, so English should not be made as a deciding factor to deciding the final merit of the candidate, rather it should be made qualifying. So this matter was referred to a committee. Committee duly considered the issue and decided that let the English be considered as a qualified, not as a merit deciding factor.
Yes.
But the issue is that this was done when the examination was on. That means the candidates are already applied and they already appeared in the one part of the examination. The other part was to be followed. So during the process, this decision was taken to make the English qualifying. But there are certain candidates, those who have scored very well in English, they made a complaint. So after declaration of the result, he's saying that, look, if our English mark would have been considered, we would have.
Now, where does your candidate clan fall?
I'm for the institution, Lordship. I'm not for the candidates. Because the Rajasthan High Court has allowed this petition relying on the judgment of K. Manjushri and this Samarjit, which is on the draft.
Tell us one thing. Oh, I see. Now, therefore, the committee said that English should be treated as a qualifying mark and not for merit. Some candidates who had scored high in English said that you can't.
No, they went to read. High Court Rajasthan. The Rajasthan High Court has ruled in their favor, stating that, look, you cannot make this rule during this process because the rule of the examination cannot be changed, relying on the judgment which is under reference, Lordship.
Now, what happened? Were the scholarships given to those then?
No, the problem is, Lordship.
What happened then?
My result was, it came after my declaration of result.
Then?
I decided the result making English as a qualifying. There are two candidates. The order went in their favor. Let the English be considered to calculate the final result.
How many candidates?
Two petitioners here.
In the High Court, two petitioners.
Before the Rajasthan High Court, Lordship.
So eventually, did they get the scholarship or no?
No, so far because this order is under stay, Lordship. Because my problem as on date is.
How much is the scholarship?
It is some 1,000, Lordship, per month.
For how many months?
It is, if the candidates are performing well, it will continue till their post-graduation study, completion of their post-graduation.
Who is appearing for them?
Candidates, they have not given appearance, any appearance from
Nobody is appearing.
No, there is no candidates.
They would have finished.
They would have finished and lost interest. They must be now.
They lost interest. In fact,
they must be now somewhere in service. Now, should we decide it on this?
Lordship, my problem is that I have to review the entire result.
2017. This was
entire result
2013.
There are n number of candidates who has.
This is National Talent Search Examination 2013 or when it was?
Yes, 2013, Lordship.
Advertisement of 2013.
There are n number of beneficiaries who has enjoyed the benefits, and if I recalculate it again on the principle that considering the English language, the entire result may be completely changed. So this is the case, Lordship.
scholarship, etc.
Oh, yes, everything, this read order came even after declaration of my result.
And you gave the scholarship to those students. There were fixed scholarships, fixed number of scholarships?
There are fixed number of scholarships. There, I think, 1,000 some odd candidate based on merit, it will be given to entire country.
So those candidates have already ended.
Already.
Now is a question of.
That is why these two candidates lost their interest and they didn't appear, given their appearance before this.
Matter here, I think.
Let's set aside the judgment of the High Court, I think. There's nothing. We'll say otherwise. Yes, Haripriya.
The problem is today, the Tej Prakash reference says that Manjushri has not taken into account Subhash Marwaha. So while your lordship has not addressed that issue in
It
this
has not arisen in any case.
Yes,
So
then your
therefore, the
lordship will just
previous
clarify
order.
that Manjushri will hold the field because it's 3 judges and Marwaha has 2 judges. Because when it eventually goes back, we will come back to this dispute whether Manjushri is
But that anyway held the field, right? Because it's a larger bench.
holding the field. But the view taken by the reference order in Tej Prakash is that Manjushri was passed without reference to Marwaha. And therefore, Manjushri has to be reconsidered. So today, the problem will arise when matters go before individual benches, whether Manjushri should be followed at all. But it's 3 judges. Marwaha has 2 judges.
And just one more sentence, my lord, like in this example.
But they can release. The earlier judgment is 3 judges, no?
No, 2 judges. Marwaha has 2. Manjushri is 3. Your lordship is right, with these issues may not arise in these petitions, but that doubt is now cast.
Because Lord, in Manjushri para 12, in my learned friends, Mr. Bharadwaj's contention, Manjushri says, suppose there is no minimum cutoff, there are 13 people, you are bound to take the 13 best people. So you can't fix the cutoff. So that is what para 12 of Manjushri says. So if Manjushri has been applied in her case, she had a right to get the 13 people, first 13, had a right to get appointed. Now, because they introduced the 75%, people below 75% went off, which is why Tej Prakash
But
says.
you know, then what would happen is that if you are bound to take the 13,
yes, ma'am.
Even if the 13th has got 40% marks, you are bound to appoint him as a translator.
That's a practical difficulty. Absolutely, I understand. But in the future situations may arise where people who have got 74, 73, 72, they won't take the 13 because they say we fixed a cutoff of 75%, which came after the results. So if you strictly apply para 12, factually lordship is right because there was no minimum. So somebody gets 1 mark, 2 marks, 3 marks, they may have to be taken. I understand that. But law.
And if I
The point is, where do you arise somewhere in a given case? It doesn't arise in these cases
May I
really.
make one more submission or no? In Tej Prakash.
So what could be done is when the matter we have now referred to two regular benches.
Yes.
So this could be thrashed out before the same 2-judge bench and let them apply their mind on the facts and overall perspective. Then the matter will come for reference to.
My only May I just make one submission? The Tej Prakash was passed by 3 judges, the reference order. Now, 3 judges have said that Manjushri has not taken into account Marwaha, which is 2 judges. And one more small submission. And it will be in Tej Prakash. And the reason your lordship is this, may I just make one more submission? Tej Prakash proceeds on the basis.
It doesn't arise properly.
It doesn't arise.
It is saying that.
Because then we will have to say that they are duty bound to take all the 13, irrespective of the marks.
Precisely. I agree with the lordship.
Which is that you have to issue a mandamus that you must select everybody. Law doesn't mandate it.
Para 12 of Tej Prakash has misread Manjushri in my opinion, and they said if Manjushri was to be strictly applied, all candidates have to be taken, whereas Marwaha is contrary. In my opinion, para 12 itself is not correct. Manjushri does not say that specifically at all. So para 12 and 13 of the Tej Prakash reference order, if your lordship will read, that now is also by 3 judges. Now, today the situation will be, will everybody follow Tej Prakash's reference order which says Manjushri is not correct, or Manjushri which Tej Prakash is wrongly interpreted?
But the subsequent judgment is of 3 judges, right?
It's not a judgment, it's a reference order.
No. Manjushri.
3 judges.
Now, you can't doubt as a matter of first principle, you cannot doubt a 3-judge bench judgment on the ground that it has not referred to a 2-judge bench.
3 judges have doubted it. in Tej Prakash.
Right, but I think that doubt itself is wrong.
Then your lordship may have to clarify.
Unless we say that the three-judge bench which decided the subsequent case is independently not correct law, then you can certainly look at it.
They'll have to see whether they will have to see whether Tej Prakash is rightly understood, Manjushri, your lordships. They will have to see if Tej Prakash is rightly understood, Manjushri.
In fact, my lords,
Because Manjushri does not say everybody has to be on that list. Specifically,
Yes.
there is no such.
All right, we
restriction.
can do this. We can see the referring order in Tej Prakash.
We will clarify.
All right, in 5, and we'll just clarify it in 2 paragraphs so that we are then done with it.
may make
Because
one
otherwise
submission,
that
my
will be
lord.
left out.
In fact, Manjushri was cited subsequently in many cases before this honorable court, and especially my lord Justice, Honorable Justice Tigesh Roy was also part of particular case from Goa, my lords, was that facts of the Manjushri case, and this is totally different. Manjushri is not applicable. That was also a change of rules after the Vemis play. In many cases, though Manjushri was cited and tried to link it or tag it along with the constitutional bench, this honorable court rejected that and said that it has to be decided in its facts.
And whereas
That's right, that's right.
Tej Prakash as well as Marwa, there is no case of cut-off marks in the interview.
Yes, so those line
was no-
line of Manjushri and line of Marwa is different.
This has nothing to do with Tej Prakash, it's totally different.
There's no conflict is a. Okay, we will.
All right, let's do this. Let us do this. If it comes to it, let us see the referral order and the 2 judgments. That's all. It will take us 10 minutes to see that. All right.
Lordship, in my case, the only problem is that post 2013, I am conducting the examination making English making.
This matter we'll close because your matter now doesn't, this has become infructuous really.
No, Lordship, the reason is that.
We're in your favor.
No, that is all right. But with respect to conducting the examination, because the largest single judge has allowed this petition relying on K. Manjushri. That was affirmed by the division bench. I am before your lordship. Candidates has not marked their appearance. I think they lose their interest.
But there is no law which has been laid down in this matter in the facts and circumstances of the case, because the candidate respondents are also, it's for grant of scholarships.
Yes, Lord.
For 1 year period.
No. It is starting from +2 to postgraduate. Based on the
That would have
continuous performance, they are
2017.
performing well, they will entitled to have the scholarship till post-graduation. But only my problem is that post 2013, after this examination, I continue with this standard that English would be qualifying only. At this stage, now tinkering with that principle of making English as an aggregate, as the High Court has ruled in their favor, will also upset the entire process, Lordship.
Do is in a minute, we will close this case and we'll just come back to Dr. Bharadwaj's case and you can just assist us for 10 minutes on Dr. Bharadwaj's case. We'll see if any conclusion may ultimately be the same, but if we have to just clarify the law in 2 paragraphs, we'll do that.
I'm ready.
Just say this. In 2013,
Lordship, my point is that they didn't qualify in the result. They only relying on the judgment of the High Court based on which they are qualified. Otherwise, result is not in their favor.
Oh, they lost. They didn't pass, you mean to say?
This High Court has said, consider his English language and grant them, they are qualified.
But if the English language marks were considered, they would have qualified, right?
Yes, that is the case.
That's the one.
That's it.
Then it's a.
In 2013,
That means in the entire result would be reviewed again.
NCERT issued an advertisement seeking applications from candidates for the National Talent Search Examination.
Stop.
During the course of the examination, candidates were subjected to two objective type tests, namely, bracket 1, mental ability test, semicolon, and bracket 2, scholastic aptitude test.
Stop.
The first and second respondents were students at the class 10 stage applied for the NTSE.
NTSE.
Full stop. Provisional results were declared. Full stop. A decision was taken to the effect that the marks secured in the language test, into bracket English, right?
English.
In the English language test,
English.
would be treated only for the purpose of qualification. Full stop. The first and second respondents did not qualify at the examination. Full stop. However, they obtained information under the Right to Information Act, in pursuance of which they were intimated that the marks which were scored in the language test were not taken into account in the final selection. Full stop. They instituted a writ petition before the Rajasthan High Court. Stop. Their contention was that they were aggrieved by the decision to treat the language test only for the purpose of qualification, as distinguished from merit. Only they were aggrieved by the language test being treated only as a qualifying test, and not for computing the merit, the aggregate marks in the preparation of the merit list. Full stop. It appears during the course of the submissions of the petitioners that the decision to treat the language test only for qualification was taken by a high-powered committee, which acted upon
That's the only committee.
by a committee.
By a committee.
Following representations which were received from students, particularly with a rural background, particularly on the basis of representations received from students. That
Students, the guardian.
Parents.
Not the student or minor.
Representations received on behalf of students to the effect that treating the language test of English for the purpose of computing the merit list would cause serious prejudice to students, particularly from a rural background. Full stop. The single judge of the High Court allowed the petition under Article 226 and directed the petitioners to determine the merit of the first and second respondents afresh after considering the marks which were scored in the language test. But this decision was taken on the basis of the judgment of this court in K. Manjushri versus State of Andhra Pradesh, 2008, 3 SCC 512. Full stop. The writ appeal was dismissed by the division bench.
Full stop. While on 12 February 2018, notice was issued in these proceedings under Article 136 of the Constitution, and the contempt proceedings which were initiated before the High Court were stayed. Full stop. Tag kiya hoga. The proceedings have been tagged together with Civil Appeal 2634 of 2013. 2634 is that Yes,
Your Lordship.
into brackets, Tej Prakash Pathak versus Rajasthan High Court,
That is the main petition.
in which a reference has been made to the Constitution bench on the basic issue as to whether the rules of the game can be changed midway after the selection process has been initiated. Full stop. In the present case, despite service, none has appeared on behalf of the first and second respondents. Full stop. We are not inclined to go into the broader question which was raised on the reference
to the Constitution bench in the facts of the present case. Full stop. The judgment of the single judge would result, learned counsel appearing on behalf of the petitioner submitted that the judgment of the learned single judge would result in a situation where the entire result would have to be redone, since a conscious decision was taken in the interest of the students not to treat the language test as a merit-based test, but only for the purpose of qualification. Full stop. If the judgment of the single judge were to be upheld, as has been done by the division bench, the result would have to be recast at this point in time, nearly 8 years after the examination has been concluded. Full stop. In the meantime, following the declaration of the results, the National Talent Search, the scholarship following the National Talent Search examination has already been awarded to a large number of students situated all over the country. Full stop. In this backdrop, and without this court expressing any opinion on the broader question of law which was sought to be raised, we are of the considered opinion that it would be appropriate to set aside the interim judgment of the High Court, which we accordingly do. Full stop. The petition लिखाना हमने the appeal shall be granted. The appeal shall stand disposed of in the above terms. All right. Now let us see Tej Prakash Pathak. Where is the judgment? Just show us from the compilation.
But it's
on page number
Vijay, I'm sorry.
110.
if your lordship can see in the
compilation.
Mr. Hansaria's volume 1 compilation, that would be at PDF page 212.
Volume 1, right?
Volume 1.
Volume 1, 212.
PDF page 212.
All right. Yes.
Lordship, please come to para number 10, first 10.
Distinction.
Under the scheme of our constitution, an absolute and non-negotiable prohibition against retrospective lawmaking is made only with reference to the creation of crimes. Any other legal right or obligation could be created, altered, or extinguished retrospectively by the sovereign lawmaking bodies.
Just a minute. PDF page, give me the page again.
212 starts.
All right.
He's reading at 216.
All right, all right.
Right, running page 214.
214.
PDF page 216.
However, such drastic power is
Wait a minute.
para 10. However, such drastic power is required to be exercised
Higher now.
Para 10, no?
Para 10. The scheme of our constitution, an absolute and non-negotiable prohibition against retrospective lawmaking is made only with reference to the creation of crimes. Any other legal right or obligation would be created, altered, extinguished retrospectively by the sovereign lawmaker. However, such drastic power is required to be exercised in a manner that it does not conflict with any other constitutionally guaranteed rights such as Article 14 and 16, etc. Changing the rule of game, either midstream or after the game is played, is an aspect of retrospective lawmaking power. While various cases deal with the situation where the state sought to alter the eligibility criteria of the candidate seeking employment or the method and manner of making selection of the suitable candidate. The latter could be termed as a procedure adopted for the selection, such as prescribing minimum cutoff marks to be secured by the candidates, either in the written examination or viva voce, Mr. Dunning Manjushri, or the present case for calling upon the candidates to undergo some tests relevant to the nature of the employment, such as driving test abroad. If the principle of Manjushri case is applied strictly to the present case, the respondent High Court is bound to recruit 13 of the best candidates out of 21 who applied irrespective of their performance in the examination held. In such cases, theoretically, it is possible that candidates securing very low marks but higher than some other competing candidates may have to be appointed. In our opinion, application of the principle as laid down in Manjushri case without any further scrutiny would not be in the larger public interest, but the goal be establishing an efficient administrative machinery. This court in state of Haryana and Subhash Chandra Marwa, while dealing with the recruitment of subordinate judges of the Punjab Civil Services, had to deal with the situation where the relevant rule prescribed minimum qualifying marks. The recruitment was for filling up of 15 vacancies, 40 candidates secured the minimum qualifying marks, 45%. Only 7 candidates who secured 55% and above marks were appointed, and the remaining vacancies were kept unfilled. The decision of the state government not to fill up remaining vacancies in spite of availability of candidates who secured the minimum qualifying marks was challenged. The state government defended its decision not to fill up posts on the ground that the decision was taken to maintain the high standards of competence in judicial service. The High Court upheld the challenge and issued a mandamus. In appeal, this court reversed and opined that the candidates securing minimum qualifying marks at an examination held for the purpose of recruitment into the service of the state have no legal right to be appointed. In the context it was held. In a case where appointments are made by selection from a number of eligible candidates, it is open to the government with a view to maintain high standards of competence to fix a score which is much higher than one required for more eligibility. Unfortunately, the decision in Subhash Chandra Marwa does not appear to have been brought to the notice of the lordships in Manjushri. This court in Manjushri relied upon P.K. Ramchandra Iyer and versus Union of India, Umesh Chandra Shukla versus Union of India, and Durga Charan Mishra versus State of Orissa. In none of the cases was a decision in Subhash Chandra Marwa considered. No doubt it is salutary principle not to permit the state or its instrumentalities to tinker with the rules of the game. Insofar as the prescription of eligibility criteria is concerned, as was done in Channa Swami versus State of Mysore, Channa Vasavaiya versus State of Mysore, etc., in order to avoid manipulation of the recruitment process and its result. Whether such a principle should be applied in the context of the rules of the game, stipulating the procedure for the selection, more particularly when the change sought is to impose a more rigorous scrutiny for selection, requires an authoritative pronouncement of a larger bench of this court. We therefore order that the matter be placed before the Honorable Chief Justice of India for appropriate orders in this regard.
Yes.
Lordship, now the para number 27, also I want to read from Manjushri.
All right. What page is Manjushri in
Yes,
this compilation?
167 for the same compilation.
How much?
167, PDF page 167.
167.
167, para number 27.
Starts at 160.
But what could not have been
We
done?
see Marwa before that, or you want to see? Oh, well, let me see Manjushri and then we'll.
First Manjushri. Lordship. But what could not have been? Para 27. Lordship.
1 second. Let's see the facts of Manjushri for a second.
Para 2, Lordship.
Yes.
Para 2 Lodge. Selection and appointments to the post of district and session judge are governed by the Andhra Pradesh State Higher Judicial Services Rule 1958. The said rules provide that 1/3 of the total number of permanent posts of district and session judge should be filled by direct recruitment. It also prescribes the qualifications for appointment but does not prescribe any procedure for selection. As the rules only prescribe the qualification for appointment but did not lay down the selection procedure. The manner and method of selection is decided by the High Court. For every selection, as and when the vacancies are notified for selection, the government of Andhra Pradesh has issued an advertisement dated 28/5/2004 inviting applications for appointment to the following 10 posts of district and session judge. Now, Lordship, para number 4. The full court of Andhra Pradesh High Court has authorized its Chief Justice to constitute committees for the convenience of administration. The resolution of the full court containing the guidelines relating to the functioning of the High Court have been compiled in the form of standing orders. 2.13 enumerates the matters to be dealt by the full court. SO 2.14 enumerates the matter to be dealt with the administrative committee. Recruitment of district judges is a matter to be dealt by the administrative committee under SO 2.14. The decision minutes of the administrative committee in regard to the recruitment of district judges are therefore placed before the full court for its consideration under SO 2.13. The administrative committee, by its resolution dated 30/11/2004, decided the method and manner of selection. It resolved to conduct the written examination for the candidates for 75 marks and oral examination for 25 marks. It also resolved that the minimum qualifying marks for the OC, BC, SC and ST candidates shall be prescribed earlier. As per its direction, the written examination was held on 31/2005 and 1026 candidates appeared for the examination. The results were declared on 24/2/2005 and 83 candidates were successful in the written examination. Due to the pendency of the litigation, interviews could not be held immediately. A committee of 5 judges was constituted for interviewing the candidates, and interviews were held in March 2006. Thereafter, the marks obtained by 83 candidates in the written examination and in the interview were aggregated, and the consolidated merit list of the 83 candidates was prepared in the order of the merit on the basis of aggregate marks. It contained the registration number, the name of the candidates, reservation category, marks secured in the written examination out of 100 marks, marks secured in the interview out of 25 marks, and the total marks secured in the written examination and interview out of 125. Thereafter, 5 more merits list in respect of categories BCA, BCB, BCD. Committee finalized the following list of candidates to be recommended for appointment as per merit and reservation and submitted to the administrative committee with a report dated 3/4/2006. Now, para number 8, Lordship. The full court considered the resolution of administrative committee dated 30/11/2004 and 4/4/2006 and the record of selection. The full court impliedly approved the resolution dated 30/11/2004, but it did not agree with the selection list prepared by the interview committee and approved by the administrative committee by resolution dated 4/4/2006. The full court authorized the Chief Justice to constitute a committee of judges for preparing a fresh list of candidates to be recommended for appointment of district and session judges. Accordingly, the Chief Justice appointed a subcommittee of 2 judges on 7/4/2006. The said subcommittee was of the view that the candidates should be evaluated with a reference to written examination, marks of 75, interviews marks of 25 as per the resolution dated 30/11/2004, instead of being evaluated with a reference to written examination, marks of 100 and interviews of 25, thereby varying the prescribed ratio between written examination marks and interview marks from 3:1 to 4:1. Therefore, it scaled down the marks obtained by the candidates in the written examination with reference to a total of 100 in proportion to a maximum marks of 75. By adding the interview marks of 25, the total marks obtained by candidates with reference to a total of 100 were recalculated. The subcommittee was also of the view that apart from applying the minimum marks for the written examination for determining the eligibility of the candidates to appear in interview, the same cutoff percentage should be applied for interview marks, and those who fail to secure such minimum marks in the interview should be considered as having failed. As the minimum percentage for passing the written examination was 50% for open category, 40% for backward classes, and 35% for ST/SC, only those candidates who secured minimum of 12.5 marks, 10 marks, 8.75 marks,
were considered as having succeeded in the interview. Consequently, only 31 candidates were found to have qualified both in written examination and interview, and a revised merit list was prepared, pruned down to 31 successful candidates. On that basis, 9 candidates were recommended for appointment as under. One vacancy relating to scheduled caste women was left unfilled as there was no qualified candidate. The said report and the selection list was considered by the full court on 28/4/2006, and it was resolved to accept the names of the aforesaid 9 candidates on the said list to the state government for appointment. The second list contains the names of 5 out of 10 candidates recommended in the first list, 2, 4, 6, 8, 10 in the first list, 1, 3, 4, 7, 9 in second list, and 5 candidates in the first list, 1, 3, 5, 7, and 9 in the first list got eliminated as they failed to secure the minimum marks in the interview, and 4 fresh candidates entered in the second list. No candidate was selected under the category of SC women, as no candidate of that category secured the minimum marks in the interview. 2 of the candidates whose names were found in the first list and who got excluded in the second list, namely K. Manjushri, filed writ petition 10061 and 10062 of 2006 in High Court, praying for a declaration that the action of the High Court in preparing the selection list by prescribing minimum qualifying marks for the interview was arbitrary and illegal, seeking a direction to the High Court to redraw the selection list without adopting minimum qualifying marks for the interview. The said writ petitions were dismissed by the High Court by a common judgment dated 30/10/2006. This appeal is by K. Manjushri, whose name was found in the first list. She contended that the minimum marks.
You can skip all that contention. The issues we can go to paragraph 17.
I just read 17. Issues are on the contingents urged the following questions arise for consideration. What was the procedure, method and manner of selection prescribed by the administrative committee for filling the post advertised on 28/5/2004, whether the list prepared by the interview committee and approved by the administrative committee suffered from any error, irregularity and illegality. Third point, whether the procedure adopted by the full court in preparing the fresh selection list by applying the requirement of minimum marks for interview also is legal and valid. The rules did not prescribe any procedure for selection. When the posts were advertised, the only criteria for selection that was mentioned was that the selection will be done by holding a
Question 1, you can go straight to question 3, I think.
Yeah.
Right, question 3.
Yes, Lordship.
That you will get it.
It's important, the manner of holding written examinations and interviews. The marks for written examination and interview, whether the candidate should secure any minimum marks in the written examination and interview, were all yet to be decided. As per the practice followed by the High Court, the entire process of recruitment of district judge was to be dealt with the administrative committee, and the decision of the administrative committee were placed before the full court for its consideration and approval. The administrative committee at its meeting held on 30/11/2004 considered the method and manner of recruitment to the adopted in regard to the said recruitment and took the following 3 decisions: that the written examination will be held on 31/2005 simultaneously at 4 centers, that the marks for the written examination shall be 75 and for oral examination 25. That the minimum qualifying marks for OC, BC, SC and ST shall be prescribed earlier. The 2 decisions are self-contained and clear. In regard to the third decision, it becomes necessary to ascertain what were the minimum qualifying marks for OC, BC, SC and ST, which had been prescribed earlier. There were no general prescription of guidelines or norms or criteria for holding the written examination and interviews marks. Therefore, the procedure to be applied in regard to each recruitment was laid down separately by the administrative committee as and when the recruitment was done. When the administrative committee decided on 30/11/2004 that the minimum qualifying marks for OC, BC, SC and ST shall be prescribed earlier, it obviously referred to what was prescribed when the previous recruitment was made in 2001 and 2. The High Court has produced the relevant minutes relating to earlier recruitment. It is seen that the administrative committee had laid down the following method and manner for recruitment to 6 posts of district and session judge. Its resolution dated 24/7/2001. Considered and resolved that the mode of examination be by way of written test for 75 marks and oral 25 marks, and the minimum qualifying marks for open categories 50 marks and for other categories of 40 marks and 35 marks. Written examination in the same ratio will be applied for the oral interview also. The minimum qualifying marks for the written examination was subsequently amended, corrected by administrative committee at its meeting held on 21/2/2002 as follows. Considered and resolved to correct the typographical error
occurred in the resolution of administrative committee meeting held on 24/7/2001 mentioning 50 marks, 40 marks and 35 marks instead of 50%, 40% and 35%. That is the minimum qualifying marks for open category is 50% for backward, 40% and scheduled tribe, 35% in the written examination. Let us to try to analyze and find out the combined effect of the resolution 24/7/2001, 21/2/2002. The resolution dated 24/7/2001 prescribed the following marks for the written examination and the interview. The marks for the written examination was 75 marks and the minimum qualifying marks was 50 marks for open category, 40 marks for the backward classes and 35 marks for scheduled tribes.
Twenty-five and 27.
25, Lordship. 25, I will now read, Lordship. When the administrative committee placed a merit list and selection list before the full court, apparently objections were raised on two grounds. One related to failure to provide the minimum 50%, 40% and 35% marks for interviews on the interpretation of resolution dated 30/11/2004, read with earlier resolutions dated 24/7/2001 and 2002. The second objection was that even though the administrative committee had resolved that the marks for written examination should be 75 and interviews would be 25 at the time of tabulating the marks secured out of 100 marks in the written examination had been taken into account without scaling it down with the reference to a maximum of 75 marks. The full court therefore appointed a subcommittee of 2 judges to examine the matter and prepare a fresh merit list and selection list. The subcommittee examined the matter and submitted a revised merit list by incorporating 2 changes. Firstly, while tabulating the marks, it scaled down the marks secured by the candidates in the written examination with reference to a maximum of 100 marks in proportion to a maximum of 75 marks, so that the final marks were with the reference to a base of 75 marks for written examination and 25 marks for interview as resolved on 30/11/2004. Secondly, it applied the minimum percentage of 50%, 40%, 35% for OC, BC, SC and ST even in regard to interviews, and consequently eliminated those who secured less than minimum in the interview. From the process of selection, the panel selection list was prepared with a reference to the fresh merit list prepared by incorporating the said 2 changes. As far as the first change is concerned, we have already held that a scaling down is unexceptional as it is consistent with the criteria decided by the administrative committee on 30/11/2004 before commencing the selection process. But what could not have been done was the second change by introduction of the criteria of minimum marks for the interview. The minimum marks for interview had never been adopted by the Andhra Pradesh High Court. Earlier, for the selection of district and session judge, in regard to present selection, Administrative committee merely adopted the previous procedure in vogue. The previous procedure as stated above was to apply minimum marks only for written examination and not for the oral examination. We have referred to the proper interpretation of the earlier resolution dated 24/7/2001, 21/2/2002 and held that what was adopted on 30/11/2000 was only minimum marks for written examination and not for interviews. Therefore, introduction of the requirement of minimum marks for interview after the entire selection process was completed would amount to changing the rules of the game after the game was played, which is clearly impermissible. We are fortified in this view by several decisions of this court. It is sufficient to refer three of them: P.K. Ramchandra Iyer versus Union of India, Umeshchan Shukla versus Union of India, and Durgacharan Mishra versus State of Orissa. In Ramchandra Iyer, this court was considering the validity of a selection process under the ICAR Rules 1977, which provided for minimum marks only in the written examination and did not envisage obtaining a minimum marks in the interview. But the recruitment board prescribed a further qualification of obtaining minimum marks in the interview also. This court observed that the power to prescribe minimum marks in the interview should be explicit and cannot be read by implication for the obvious reason that such deviation from the rules is likely to cause irreparable and irreversible harm. This court held that as there was no power under the rules for the selection board to prescribe the additional qualification of securing minimum marks in the interview, the restriction was impermissible and a direct impact on the merit list, because the merit list was to be prepared according to the aggregate marks obtained by the candidates at written test and interview. Once an additional qualification of obtaining minimum marks at the Viva Voice test is added to candidate who may figure high up the merit list, was likely to be rejected on the ground that he has not obtained minimum qualifying marks at the Viva Voice test. To illustrate, candidate who has obtained 400 marks at the written test and obtained 38 marks at the Viva Voice test, it considered on the aggregate of marks being 438 was likely to come within the zone of selection, but what would be eliminated by ASRB on the ground that he has not obtained qualifying marks at Viva Voice test. This was the impermissible and contrary to rules, and the merit list prepared in the contravention of rules cannot be sustained. In Umesh Chandra, the score of Delhi Judicial Services Rules 1970 came up for the consideration. The rules provided those who secured the prescribed minimum qualifying marks in the written examination will be called for Viva Voice, and that the marks obtained in the Viva Voice shall be added to the marks obtained in the written test, and candidates' ranking shall depend on the aggregate of both. 27 candidates were found eligible for appear for a Viva Voice on the basis of their having secured the minimum prescribed marks in the written examination. The final list was therefore expected to be prepared by merely adding a Viva Voice marks to be written examination marks in regard to those 27 candidates. But the final list that was prepared contained some new names which were not in the list of 27 candidates who passed the written examination. Some names were omitted from the list of 27 candidates who passed the written examination. It was found that the selection committee had moderated the written examination marks by addition of 2% for all candidates, as a result of which candidates who did not get through the written examination became eligible for Viva Voice and came into the list. Secondly, the selection committee prescribed for selection and a minimum aggregate of 600 marks in the written examination and Viva Voice, which was not provided in the rules, and that resulted some of the names in the list of 27 candidates being omitted. This court held neither was permissible dealing with the prescription of minimum 600 marks in the aggregate the court observed. There is no power reserved under Rule 18 of the rules for the High Court to fix its own minimum marks in order to include candidates in the final list. It is stated in para 7 of the counter affidavit filed in writ petition that the selection committee has inherent power to select candidates who according to it are suitable for appointment by prescribing minimum marks.
3 actually, because then he refers to one more judgment and then goes to para 33.
Lordship, 32 also.
All right.
In Maharashtra, SRTC and Rajendra Bhimrao Mandve, this court observed that the rules of the game, meaning by thereby that the criteria for the selection cannot be altered by the authorities concerned in the middle or after the process of selection has commenced. In this case, the position is much more serious. Here, not only the rules of the game were changed, but they were changed after the game had been played and the results of the game were being awaited. That is unacceptable and impermissible. In 2004, merely adopted the procedure prescribed earlier. The previous procedure was not to have any minimum marks for interview. Therefore, extending the minimum marks prescribed for written examination to interviews in the selection process is impermissible. We may clarify that the prescription of minimum marks for any interview is not illegal. We have no doubt that the authority making rules regulating the selection can prescribe by rules the minimum marks both for written examination and interviews, or prescribe minimum marks for written examination but not for interview, or may not prescribe any minimum marks for either written examination or interview. Where the rules do not prescribe any procedure, the selection committee may also prescribe the minimum marks as stated above. But if the selection committee wants to prescribe minimum marks for interview, it should do so before the commencement of the selection process. If the selection committee prescribe minimum marks only for written examination before the commencement of selection process, it cannot either during the selection process or after the selection process add an additional requirement that the candidates should also secure minimum marks in the interview. What we have found to be illegal
Now seen, we'll come back. We'll come back after lunch.
Okay.
After this, we will look at Marwa, and then you can make your submissions on it. And then we'll hear what all of you have to say.